Good morning, everyone. Thank you for being here this morning. And welcome to this session entitled Product Safety in the Promotional Products Industry. Your speaker this morning, Susan Duragan, is the Associate Director of the Toys and Premiums Group at ULSTR. With over 25 years of experience in the toy and children's product industry, Susan has conducted numerous technical seminars and webinars and works closely with companies to provide the highest level of quality service in the areas of product tasting, quality assurance, safety evaluations, and inspections. Please join me in welcoming Susan.
Great. Thank you. We very much appreciate being invited to speak here. We work very closely with the promotional products industry and have for several years. My colleague Haley Will is a primary account executive who works with both suppliers and distributors to help ensure that the product complies with the regulatory requirements, because we're really ultimately we all want the same thing, to get safe, compliant product to the market on time, within budget. So thank you again for inviting us to speak here. Today we're going to talk about three primary categories. We're going to talk about the U.S. regulations, including the Consumer Product Safety Improvement Act. We want to talk about the Canadian regulations, kind of compare and contrast too, including the new Canada Consumer Product Safety Act. And then we're going to get into some of the primary promotional product categories and discuss the requirements, both U.S. and Canada, for specific types of promotional products. We have a small group here, so I really encourage you to be interactive, ask questions as we go along. Really don't want it to be a lecture, but really a learning experience for everybody. So we're going to start with the U.S. regulations. And before we get into the specifics of the Consumer Product Safety Improvement Act, I did want to mention product safety has been regulated for many decades. The Consumer Product Safety Commission in the United States was established in 1972. They are responsible for the safety of over 15,000 different consumer products. And there's different acts that they enforce. The Federal Hazardous Substances Act is probably the biggest one, and it covers a wide variety of consumer products, including children's products, and a lot of the new provisions of the CPSIA have been incorporated into the Federal Hazardous Substances Act. The Flammable Fabrics Act actually predates the CPSC. It was established in the 1950s, so it's been around for a long time, and affects the flammability of wearing apparel, essentially, as well as carpets and rugs and mattresses. And the Consumer Product Safety Act includes the ban on lead-containing paint, and then also includes regulations for a lot of non-children's products like lawnmowers and ATVs and garage door openers. And then there's some other specific acts. The Poison Prevention Packaging Act is really the child-resistant containers, Refrigerator Safety Act, and the Pool and Spa Act. And in addition to the CPSC in the United States, there's also the Food and Drug Administration. So the FDA regulates other types of products and to different requirements, primarily food, drugs, cosmetics, and food contact items. And that's really where the FDA regulations apply primarily to the promotional products items, with regards to cups and mugs and lunch bags and those types of products. But also the cosmetics, the lip balm, covered by the FDA, food items covered by the FDA. So despite all this regulation, and again, that's been around for many decades, we had a lot of recalls. 2007 has been called the year of the recall. There was over a recall a day. Many of the recalls were toys, And many of the recalls were for lead in paint, which, again, has been regulated since the 70s. So consumer confidence, took a nosedive, and Congress realized they needed to do something. We had these laws out there, but they weren't being strictly enforced. And so the Consumer Product Safety Improvement Act was created by Congress. It was enacted in 2008, and it applies to all CPSC-regulated consumer products, so those 15,000 categories of products. It's been called the most comprehensive overhaul of consumer product safety rules since the CPSC was established in the 70s. Two major things it did is make compliance mandatory. You need to have proof of compliance. And for children's products, it requires third-party testing. You no longer can self-certify. You have to have children's products tested by a third-party CPSC-recognized laboratory. If the number of recalls is an indicator of the effectiveness of the CPSIA, then it does seem to be working. The number of recalls have consistently decreased, especially in the toy area, since 2008, down to 34 recalls in fiscal year 2011, the last reported year, and only 4 of those were for lead and paint. So it seems to be working. People seem to have gotten the message that compliance is mandatory, and it seems to be working. Another factor may be that the CPSC is working closely with U.S. Customs and Border Protection and doing a lot more port surveillance. So they're actually stopping, if there is non-compliant or unsafe product, they're stopping it at the ports through these inspections. So that may be another factor that recalls are down because these products aren't even making the store shelves. So we're going to review the main testing requirements of the CPSIA. We're going to look at these 6 sections here. And again, as we go through, if you have any questions, please feel free. And we want to start with a definition of a children's product because a lot of these new requirements are specifically targeted to children's products. And when the CPSIA first came about, a lot of people thought it's more regulations on toys. And it's not just toys. It's all consumer products, but with a lot of new requirements for children's products. And a children's product is defined as a consumer product primarily intended for children 12 years of age or younger. So that certainly includes toys, but it also includes wearing apparel and backpacks and stationary items and drinking vessels. I mean, a wide range of products. The CPSIA does include 4 factors to consider to determine if you have a children's product. And again, it's important to know if it's a children's product versus a general use item because there's a lot more testing and labeling required if it is a children's product. So the first factor is the statement by the manufacturer about the intended use of the product. And that's typically in the form of an age grade or an age label, intended for children 6+. If it's reasonable. The second factor is how is it advertised? What's shown on its packaging? If there's kids shown using the item, playing with the item, you may very well have a children's product. Where is it sold? If it's sold in the children's department of a store, then it's probably a children's product. Another factor is whether it's commonly recognized by consumers as being intended for use by a child. And a good example of that is stuffed animals. You may have a stuffed bear sold with a gourmet coffee set in the ceramic mug, so that product itself is intended for adults. But in the end, that stuffed bear is still a stuffed bear, and that's commonly recognized as being used for children. So you'd want to make sure that that stuffed animal meets all the child safety requirements, even though it's sold with an adult kit. And lastly are the age determination guidelines that were issued by the CPSC. Those guidelines include various categories of children's products and really look at the characteristics of the product in comparison with the ability of children to use the product at various ages and their interest in the types of products. So it's 300 plus pages long. It's on the website, and it's something you can refer to determine really, is this something children can use? What would be the most appropriate age? And in addition to those 4 factors that are listed in the CPSIA, you may want to consider other factors. Especially in the promotional products industry, it can be a challenge because you could be getting a blank, maybe made overseas, and then here you may be then applying a logo or some type of artwork to the product, and it ends up perhaps being a children's product. You don't always know when you're buying the blank who the end user is going to be. So you want to look at things like size and shape. With drinking bottles, is it small? Is it 12 ounces or smaller? Does it have like easy to grip sides? Is it something that a child would use? Or is it so big that really it would be hard for a child to hold and to use properly? You can look at materials, soft, pliable materials, wood even, typically more targeted to children as opposed to metal, glass, ceramic materials. The number of parts plays a factor, the motor skills required. Could a child even possibly do the puzzle? You look at colors. Children like the bright primary colors typically, whereas an adult item may be more realistic colors. So if you have a car, for example, and if it's very detailed and it looks like a miniature of the real car, that's probably more for adult than if you have a larger, brightly colored, pretty simplistic vehicle that is freewheeling that a child's going to use. So different things to consider. I know with collectibles, we've had some challenges where someone has a car, comes with a base, but it's easily removable from the base, and the horn works and the doors open and the hood lifts up and it's freewheeling, and their target audience is an adult, but it has so many features that make it appealing to a child that we would always recommend erring on the side of caution and really making sure it's safe for a child because of those features. It's certainly foreseeable a child's going to be using it. And again, licensing and theme is a big part, especially in the promotional products industry, in determining whether you have a children's product or an adult item. The bears you see on the screen all have the Hertz logo, so obviously Hertz is the car rental company. Adults use the rental cars, but in the end, it's still a plush bear. It's still something that children are going to use. I don't know. Can I just ask, do you guys do a lot of children's products, or it's more targeted to adults? What types of products do you do?
A lot of clothing.
Okay.
Bags.
And with clothing, that's somewhat easier to distinguish between children's product and adult items because you can go by the size. Okay. How about you?
Well, we have virtually nothing that is specifically designated for children of 12 and under. We're a plastics supplier mostly. But we started to try to be more sensitive to when it would be clearly a child imprint. But we do third-party testing, so it's available for any distributor that would ask, but we still will count on the distributor if it is a child imprint to take the initiative to determine that they want, that they want the documentation. We still provide that on request. And or a tracking, like we've only been asked to do a tracking once.
Okay.
A tracking label once, and it was on a flyer, and it was a clear children's imprint.
Mm-hmm.
So otherwise, it really hasn't been an issue for us.
Yeah, but that's a good point. I mean, you need to know where it's being sold, how it's being imprinted, to whom it is, and you don't always know that when you get the blanks. And that's where getting as much information as you can beforehand to ensure that it meets the appropriate requirements is important.
Well, and it seemed for a period of time when the product safety was really starting to come to the forefront, and I would attend some early sessions, and was talking to fellow suppliers, it almost became like, are we supposed to just automatically recommend putting a tracking because of a children's imprint? But we all came to the conclusion pretty quickly, it still needs to be on a request basis.
Okay. Although some items I would imagine that you would, if you were doing plush, for example, you'd always consider that a children's
Right,
product. But
being that our items are not designated for children, again,
Right.
going back to the imprint portion of it on otherwise multi-generational product.
Mm-hmm. Okay. So we're going to get into now the specific requirements of the CPSIA. And for some of you, this may be a refresher, but there is some new information out there. That's one thing. It's continually changing. It's continually being updated. The CPSC just had a session yesterday, a hearing on some proposed changes to the rules, and I'm waiting to hear how that ended up. But Section 101 is the ban on lead-containing paint as well as lead content. And as I mentioned earlier, lead paint has been banned since '78, specifically for paint sold in the wet form, for paint used on toys and other children's products, and for paint on certain furniture items. And the limit since '78 was 600 parts per million. With the enactment of the CPSIA, it went down to 90 parts per million. Sounds like a huge jump, but really, either you have leaded paint, and there's a lot, or you have minimal traces of lead. We really didn't find many that were between the 90 and the 600. Compliance is mandatory. Third-party testing is mandatory. You may test the wet paint. The CPSC does allow for what they call component testing. If you do test the wet paint, it's the finished product that has to comply in the end. So if you are relying on component testing and you do test just the wet paint, you want to make sure it's that exact paint that's being used in your finished product in the exact composition. So if they add thinners before applying it, you want to make sure that the thinners are also tested. So it needs to be traceable to your product. And you want to make sure that the manufacturing process itself doesn't allow for any lead contamination. We had a case several years ago, before CPSIA, where we had tested some wet paint at one of our labs in China, and it's just as part of pre-production testing, and the wet paint complied. They then went and screen printed some shirts, and we tested the finished product. We scraped the paint off and found it was high in lead. So we're like, how can that happen? The wet paint's fine, the finished product has lead. And we did an investigation and found that during the manufacturing process, you periodically have to clean the screens. And they were cleaning them with leaded gasoline. And so the first few shirts that were produced after each screen cleaning had high amounts of lead from what was being used to clean the screens. So if you're using just the wet paint testing to certify the finished product, you really want to make sure that there's no potential for contamination along the way. The use of HD XRF is allowed to confirm compliance to the lead limits, which is good. Because the wet paint testing itself is destructive. You're destroying the product. You're scraping the surface coating off of the product. It takes longer. So being able to use an XRF machine to evaluate the paint requires fewer samples. It's quicker. It's less costly. So it can be done. And the good news, you'll see Canada does have the same lead limit of 90 parts per million for total lead in paint. Yes?
For example, in China, you run a test for lead, particular product, and you test to either European standard or regulation, Canadian regulation, or U.S. regulation. The determination comes back that you've got less than 90 parts per million. Is that acceptable in all the countries? because the ultimate determination is that it is less than the standard. Could you comfortably issue a general certificate of compliance in the U.S. based on Canadian test standard or European?
For
Or do you need to have it tested each one of those regulations?
You don't have to have it tested to each one of those regulations as long as the test methods are the same. So for total lead, U.S. and Canada both have a requirement for total lead. Canada's requirement is more specific to like items for children under 3, but regardless, there's a limit. And it's the same test method. So you could test it once and certify compliance to both U.S. and Canada. Europe doesn't have a total lead requirement, so we don't even need to worry about them. U.S., Canada, and Europe do have requirements for other heavy metals for migratable amounts of those heavy metals. And the other heavy metals are like antimony, barium, cadmium, mercury. The European and the U.S. test method is the same. Canada has a unique test method that's just different. And you can't even say one is more stringent than the other. It's just different. So in that case, you would have to do 2 separate tests, one to Canada and one to U.S. and Europe. And I know that U.S. and Canada in particular are working very closely to help align the standards. And so I think we will see more alignment as we go along. I attend the ASTM meetings for the toy safety standard, and Health Canada is always present and always actively participating. So where it is the same, you don't have to do duplicate testing. But if there is a difference that could affect the pass-fail of the product, then you do have to do the 2 separate methods.
How many, you're touching on the multiple levels, say for Prop 65.
Yes.
Everybody seems to be targeting 2
Yeah.
that we'll test for, and that seems okay.
You're saying the lead and the cadmium?
Yeah, but
Right.
how far do they expect you to go?
Prop 65, we could do a whole session on that alone. Prop 65, for those who don't know, is a state law in California. It was intended to help prevent unsafe chemicals from getting into the drinking water, but it's morphed into this law that lists over 800 chemicals so far, and they're continually adding. And all it says is, if you have these chemicals, and in some cases they give you limits, then you have to have a warning, because the consumers of California need to know if they're buying something that contains a chemical that may cause cancer or reproductive harm to consumers. There's no way anyone can test for those 800 plus chemicals. And so you're right, they're targeting specific chemicals like lead and cadmium. Phthalates is another one that they're looking at. And so how do you comply with Prop 65? What we recommend is looking at regulations, and there are regulations for lead, and there are federal regulations for lead and for phthalates. Meet the regulations that are out there, and then look at the settlements too. A lot of our testing is based on settlements. And what happens with the settlements is that anyone, a consumer, can make a claim against a company and say, we think your bags have high levels of phthalates, and you either have to prove that they don't, or you just settle. You pay money, and which is usually what happens, is there's a lot of settlements. And with the settlement, you've confirmed that, your bags will never contain more than, 200 parts per million of phthalates. So we do test to the settlements where it's appropriate if you have a similar type of product. It's not 100% guarantee, because someone else could bring a claim against you, and they could require no more than 100 parts per million phthalates for your particular product. So it's no guarantee, but it's a way to cover yourselves, and it's a way to make yourselves a hard target. For Prop 65, look at the settlements of similar product and comply with those, and then look at the regulations. And even if phthalates, which we'll talk about shortly, even if it doesn't apply from a federal level to your particular product, if there's been Prop 65 settlements on phthalates, you may as well comply. I mean, it's just protecting yourself rather than having to go through and pay tens of thousands of dollars in a settlement.
Is it true that there's bounty hunters
Yep.
in California?
Yeah. It's just crazy. That's how some people.
California, or is that something all over?
So far, it's just California. But other states are starting to enact their own chemical management requirements. So Washington State, for example, requires reporting of certain chemicals in certain types of materials by certain companies. And I would imagine that the California bounty hunters are looking at who's reporting to Washington and will probably go after those. I mean, I think it's just going to expand. So I think if you're aware of what chemicals are in your products, you're trying to make yourself a hard target by testing to what regulations are out there and the settlements, it helps. I mean, they're going to go after someone who's easier, right? So, yeah, I'm sorry, we didn't cover Prop 65 here or any of the state regulations, but it's a really good question and something that people need to be aware of. You can't just meet the federal regulations because there's Prop 65 and there's other state requirements, unfortunately. Yes?
Have you done to make sure that you meet all the state requirements? Because the fact is that you never know where a product's going to end up.
Right.
A product at a convention, people have come from all, like Canada, US, potentially all different states. That product can end up anywhere.
Right. And so the question is there testing you can do to meet all of the state regulations? And there's no way you could test for over the 800 chemicals of Prop 65. What a lot of people are doing is, in addition to the targeted testing we just talked about, is also just requiring their suppliers to sign a statement. I mean, it's as good as the paper it's written on, I suppose, but at least it shows that you're aware and you're trying to take some due diligence to protect yourselves.
So then when we fill out a request for quoting, knowing from our client, or they tell us where the event is. So we usually test or request testing for Canada or US.
Mhm.
Should we be testing for both?
Depends where your product's going. I think,
But that's just it, like, that question, you don't know if it's a trade show and visitors from all over the place. So potentially, even though the client has said the event is in Canada, there could be visitors from the US. So should you be requesting or testing, checking off both Canada and the US?
it certainly doesn't hurt. But I think really, I mean, it's based on where you're distributing the product to, because you could have a visitor from Australia too at the show. You know, you can't cover the whole world. So it's really where you're distributing it. So if you're selling the product in Canada or distributing the product in Canada, it needs to meet Canadian requirements. But if you're selling the product to a U.S. distributor, and so you know it's U.S. distribution, then you would want to test to the U.S. as well. And when testing to the U.S., not just the federal regulations, but look at Prop 65 and states as well.
So is there any state regulations that if it passes that one state, kind of say, so going back to you can't necessarily test for Canada and the US, if it's going, if it's being distributed in the US, you'll focus on US regulations. But again, it still goes back to there's all different states have different regulations. So is there any one state that could kind of make it safe that it's for the rest type of thing? I have this situation that is something I need to consider, so that's why I'm curious.
So you can test for U.S. and Canada, first of all. I mean, that's not too hard. A lot of the Canadian and U.S. regulations are the same, so you just want to test for whatever's different. You'd want to meet Prop 65. The good news is there's not a lot of different state legislation enacted. There's a lot being proposed, but you'd want to meet Prop 65. There are the new chemical reporting requirements in the state of Washington, but it's very specific to certain types of companies. It's based on the size of the company and certain types of products. But we'd be glad to send you just so you know what the reporting rule is. It's a phased-in approach, and it goes through, I think 2018. So right now, the most critical products, they call them the tier 1 products, are things that like lotions, shampoos, or anything that you'd ingest. So anything in direct contact with the skin or that you'd ingest. And the largest companies, over $1 billion, have to report now. The tier 2 products are apparel, things that are in direct, prolonged contact with the skin, but that are not absorbed by the skin. So apparel is a tier 2 product. Right now, only the largest, the $1 billion companies have to report. But there is a tiered approach, and eventually all companies will need to report. The tier 3 products are the skin contact, but not for long periods of time. So those are the ones, the incidental, the toys and the luggage and, things that you're just going to have some contact with the skin, but it's not prolonged. And those you report later. So if you'd like, we'd be glad to send you some information about that. Maybe if you want to just give us your card after, or we can even send it to Chantel and she can post it, if you think that would be helpful.
Now, you touched on suppliers providing documentation to distributors and users. Are general certificates of compliance enough? I mean, so you give somebody that, are you taking them off the hook? Because there's circumstances where they want to come back and they want to see the actual test report.
I think it's smart.
Some of that has sensitive material information on those test reports, i.e. factory groups,
Mhm.
sources. Does the supplier have the right to white up that information? So you can see the product, you can see the test report, but you're not seeing their factories.
Sure. I think the certificates themselves, particularly for children's products, but any certificate has to be based on some type of testing, some type of knowledge that the product does comply. The children's product certificates have to be based on third-party testing. And I think it's smart to ask for a copy of the test report because you may want to see the actual results. So they're saying it passes lead. What if there's like 80 parts per million in there? So technically it passes, but that's pretty close to the limit. Do you really want to accept it, or do you want to find something where there's none detected? So I think it's smart to ask for a test report which backs up the certificate. And certainly they could white out, information like the factory, which you don't need to know. You just need to know if it's safe, if it complies.
If we see from one of our suppliers with products that it's meeting the requirements for Prop 65, would we expect that they're testing every batch that comes in? Or are they testing once a year? Or what would we expect?
So there's no testing requirement even for Prop 65. It just says if you have it, you have to label it, right? So you're testing to determine if you do have to label it, if you have one of those chemicals that may require labeling. And you're testing for certain targeted chemicals. You don't necessarily, for anything, have to test every batch if you know it's identical to that first batch that was tested. But you do have to know that. So you have to know it's the same materials, it's the same manufacturing process, it's the same factory. I mean, if they have that confidence, you don't have to test every batch. You can just test once a year, perhaps. Or if there's a change, if they use a new factory or if they use a new supplier of the raw materials. That's something that in the United States is being enacted on February 8th. Is the reasonable testing program requirements. And the requirement is minimum annual testing or if there's any material changes. So, from your standpoint, you may not feel as comfortable accepting a Prop 65 compliance report from 2 years ago. You want something that directly affects your product, that's related to your product.
But I would, as I was reading it, I was doing some product sourcing and things, and there's one company in particular that almost all the products say meet Prop 65. It's a large company. I assume they've done their due diligence and made the wrong assumption.
At least they're aware of it and they're listing it.
If a supplier really should be doing it by the kilo, even if you're not changing factory, because you can never be assured that the source materials are going to be the same place.
But that's, I'm talking for the regular stock items.
Right.
That I'm
So when I have a particular PO petition, or I come in, that PO is tested. And that PO is unique, it shows up, for example, on Flush Bear, will show up for tracing purposes. If I'm resupplying next year, or if I'm resupplying later in the year, on a whole other different production run, I would retest. Just to be on the safe side, because you can never be sure that factory went to the same supplier for the lead, for the plastic, whatever it was, or not lead.
Mhm.
I don't believe that that would be happening at all. And I would say, from a supplier perspective, I don't know that that's required. It sounds great, but I'd like to know that these major suppliers who restock a number of times a year, I have to believe that they are not testing every lot. I was under the impression, prior to this, that that testing could be done every 2 years. Now, we know, if we have made, like we just recently made a change in a factory, of course, we immediately get new testing done. We have a couple programs where the distributor requires testing every year, no problem. We do the testing every year, but it is expensive.
Mhm.
And we have been up to this time, so I'll be curious to follow the reasonable testing requirements, because we have been doing a minimum of every 2 years. Okay, and then we require, then like we're in the process of updating our testing right now, getting additional third-party testing for the ones that are going into the third year, but the second year has expired.
Mhm.
But otherwise, up to this point, we've had the same consistent factories, we do a lot US, we've had consistency, which again, doesn't mean anything anyway. What you test, you could have 2 containers and you do a random test for both, you don't know. Still, it's still the luck of the draw, to some extent.
Yes.
And you just have to know your factory right?
Yeah, exactly. So with the first of all, the reasonable testing program doesn't go into place until February 8th.
Right.
And the minimum annual testing is specific to children's products at this time. The CPSC hasn't established the reasonable testing program for the general use or the adult items. There is an allowance for testing every 2 years, even for children's products, in the reasonable testing program regulation, if the factory has a robust production testing plan in place. How are they ensuring, in between that certification testing, that the product complies? So the CPSC would be looking for the factory's quality controls that has to include recurring testing. Not by the third-party lab, but just some type of recurring testing. Statistical process controls, are they using a go, no-go gauge on certain critical dimensions? So there is an allowance for children's products for testing every 2 years, or even every 3 years if you're using an ISO 17025 lab. But I do think most of the time people are going to be doing that minimum annual testing for children's products.
Children's products still being the distinguishing
Right.
criteria.
Right. So we have yet to see what they're going to say for general use. Right.
Multi-generation, whatever.
Yeah. And you're absolutely right as far as the testing itself. What are we testing? 6 samples out of whatever the lot size is. The certification testing is based on the assumption that all the product is the same, that the samples that we're testing are truly representative of the entire lot. Otherwise, if there's wide variability, our test results are only going to be as good as those 6 samples that we tested. So you have to know your factory, like you said, and you have to feel confident that they have the appropriate controls in place to make sure they're making the same product each and every time. It's a challenge. Just continuing on with the CPSIA, one of the things that it added for children's products was a requirement for lead content in the accessible substrate materials. So we're no longer just looking at paint, but we're looking at the actual substrate material. The limit is currently 100 parts per million. Compliance is mandatory. Third-party testing is mandatory. You can do component testing. So if you're doing apparel and you have buttons and you're using those same buttons on 10 different SKUs, you can test the button just once, again, as long as you have the traceability that it's identical. Canada's requirement actually is 90 parts per million for certain products for lead content. And again, it's those products that are going to come in contact with the mouth or anything that's for children under 3, essentially. So here, if we were doing total lead content for US and Canada, we could still do the test once and just use the 90 parts per million, the more stringent limit in Canada. And there are some exemptions from the lead testing rule. When it first came out, you had to test everything. Cotton, paper, things that just would never contain lead. But there are material exemptions, so you don't need to test these materials because the CPSC feels confident that they just wouldn't contain excess lead. The next is the mandatory third-party testing and those general conformity certificates that we've been talking about. As of January of last year, third-party testing by a CPSC-recognized laboratory is required for pretty much all children's products. There's some exemptions in the durable nursery products, things like high chairs and strollers, that are being enacted on a rolling basis. But essentially, children's products require third-party testing. There's a whole list of laboratories on the CPSC site. There's over 100 laboratories. They're located globally, so testing can easily be done at the country of manufacture. The certification is the responsibility of the importer if it's made overseas, or the domestic manufacturer if it's made in the U.S., and this does apply to all the consumer products covered by CPSC enforced regulations, so those 15,000 products. And there is a suggested format for the certificate on the CPSC website. You need to include these 7 items in the certificate. So again, certificates are required for any CPSC regulated product. They have to be based on third-party testing for the children's products. And so you have to have the identification of the product, and it has to be specific enough so that you can match up the certificate to the actual product. You need to include a citation of each of the product safety regulations that the product's being certified to. So you can't just say meets all CPSIA requirements. You actually have to list 16 CFR 1303, lead in paint, ASTM F963, section blah, blah, blah for heavy metals. The certificate needs to include the identification of the U.S. importer or the domestic manufacturer, so essentially the person issuing the certificate, along with contact information of a specific person that they can contact should there be any questions on the certificate. You need to include information on the certificate about when and where the product was manufactured. So not just made in China, but it needs to be more detailed to indicate where, the province, not necessarily the actual factory, but the province. And the date can be month and year. The date and place where it was tested for compliance, and the identification of any third-party lab, which would again be mandatory for children's products. Tracking labels is another part of the CPSIA that's specific to children's products, and it's really been quite a challenge for a lot of companies, but particularly in the promotional products industry. So the requirement is that there be permanent distinguishing marks on the product and the packaging to indicate when and where it was produced, along with the manufacturer or private labeler name and other tracking information. And the whole purpose is to, in the case of a recall, to be able to identify the affected product. In this case, the location of production actually has to tie back to a factory. Need to know what factory the product was produced at. And you can use a code. So you could have on the product the company name. There has to be someone that the consumer can contact. But then there can just be a code. So you could say like WS0113. That could mean what to you when the consumer contacts you. It could mean like washing factory. in January 2013. So you're not giving out the factory information, but from the code, you can tell where it was produced. So that's a requirement. Yes?
Cover this, and I apologize if I came late, that when you're speaking of children's products, what determines whether or not it's a children's product?
Good. It's defined in the regulation as anything intended primarily for a child 12 years of age or younger.
So, for instance, if we sell a calculator that's being distributed at a convention, we could reasonably assume this is going to get into the hands of most people's kids.
But is it primarily for children? Like with a calculator, if it's your standard calculator, I'd say it's a general use item. If it's intended for children, if it's targeted for children, the calculator may be in bright primary colors, it may have larger buttons. You know, there would be features that would make it primarily intended for children. But your standard calculator, I would say, is a general use item.
So something like that, I looked at one the other day, it came in on my email, it had a maze on the back of it, that would probably.
Oh,
So you'd want to
yeah,
probably target
that,
children's products.
yeah, I would agree. The CPSC hasn't really said what to the extent practicable means for this tracking label requirement, but they do give some guidelines. So they talk about the size of an item. On a calculator, you could probably easily imprint something with the tracking label information, but on a pen, it may be more of a challenge. And they talk about the type of material. There's just some materials. If you have craft items like pipe cleaners, you can't imprint anything on that. So they look at the material. They look at whether you can aesthetically include a label without really marring the aesthetics of the product. For shirts, it's pretty easy. You could include it on the sewn-in label. You could include an imprint like on the underside of the hem. There's ways of doing it, but it certainly can be a challenge. It has to be permanent, so you can't just use removable hang tags or standard adhesive labels that can easily be removed. In the promotional products industry especially, it's a challenge because you may end up needing two tracking labels. One, if you're importing a blank. So if you're importing those shirts that are, youth sizes, you'd need a tracking label for that to identify when and where those shirts were made in China. But then here, if you're doing the decoration, you'd also need a tracking label for the decorator. You need to know when and where they were decorated in case a problem arises with the inks. So in the promotional products industry, you may very well need two tracking labels. And I can tell you, the Promotional Products Association in the U.S. has met with the CPSC and talked about these challenges and gotten confirmation from the commission that, yeah, it's true. You may need two.
And since you're referencing PPAI, the one time that we were asked to do a tracking label, registering it through PPAI's product safety website was about the easiest thing. I mean, all the, you feel like it's so complex, and then you kind of start to break it down, and you try to keep it straight, and you think, okay, I think I have my finger on it. And then, like I said, when I had to do the first registration, somebody said it was easy, and I thought, oh God, I hope it's really easy. It was great. It was
Good.
great. So that is the least complicated part of it. It was really very
Good. So, yeah, PPAI developed a system where your tracking label would just be the URL, correct, to the PPAI site. And then on that site is where all of the information is listed.
You just get that number, and then you put that on.
Right. And they did run that by the commission, and the commission approved it. So it is acceptable to use. Good. Oh, I'm glad to hear that. Tracking labels, interestingly, are something that the commission is finding more and more problems with during their port surveillance activities. So they're not going to stop a product because it's missing a tracking label or there's something incorrect with the tracking label. But as what they're calling a secondary offense, they are finding that, if they've stopped a product because of lead content, they're also finding that there's problems with the tracking labels. So it is something that they're looking at. It's not going to cause your product to be stopped for that reason, but it may be identified as a secondary offense if there's a problem with it. Oh, and here's the PPAI tracking label system. Section 105 is the labeling requirements for advertising toys and games. So this does not apply to all children's products. It just applies to toys and games. Under the Federal Hazardous Substances Act, there's specific warning statements required for certain items. So if it's a toy or game intended for children between the ages of 3 and 6, for example, and it has small parts, you have to include a small part warning statement. If it has small balls, you have to include a small ball warning statement. And so really the CPSIA requirement is just that if the product requires one of these warning statements on the packaging, if it were being sold at retail, those warnings also need to be on the internet site or in the catalog where consumers can also purchase the product. So it's just giving the consumers that same type of information that they'd get if they were buying at retail. Section 106, mandatory toy safety standards. ASTM F963 has long been an industry standard for toys in the United States. It was, as part of the CPSIA, adopted as a mandatory federal rule. Compliance is mandatory. There's currently 2 versions still out there. It's a little confusing, but for 08 version, you have to certify, you have to test and certify, so that has to be included on your children's product certificate if you have a toy. But compliance to the -11 version is also mandatory. It's just not yet required to certify compliance. That's part of what the meeting yesterday was about, was to adopt the regulation that would allow testing and certification only to the -11 version. So, the F963 includes all of the federal requirements for toys, so it includes the ban on lead-containing paint, and it includes the various use and abuse tests and flammability. Then it has a lot of additional requirements for specific types of toys. So there's requirements for sound-producing toys, for cords and elastics on toys, for projectiles. New requirement in the -11 version is a requirement for heavy metals in substrate materials. Essentially, the ASTM standard adopted the European requirements for heavy metals in substrate materials. And last section we're going to talk about of the CPSIA is the ban on phthalates. And this is specific only to children's toys and childcare articles. And childcare articles are those designed to facilitate feeding, sleep, teething, sucking for children under 3 years. For all of these products, there's a limit of 0.1% for 3 of the phthalates. For the other 3 phthalates, it applies only if it's something that can be placed in the child's mouth. Same limit, interim ban. And it does apply to accessible materials only. When this first came out, it applied to everything. So you could have an internal squeaker in a toy that a child's never going to access, and it applied. Canada does have a phthalate ban too, but it's specific to infant items made of vinyl material. Phthalates is a big issue with Prop 65. So if you have an item made of a material that may contain phthalates, testing is recommended. So the CPSC did provide a list of materials that may contain phthalates, and so must be tested, and then a list of materials not likely to contain phthalates, and so testing is not required. I did want to mention that CPSC also has a small batch manufacturers registry. And small batch manufacturers are those that earned less than $1 million in gross revenues from the sale of all consumer products and produced no more than 7,500 units of at least one consumer product. By registering with the CPSC as a small batch manufacturer, you're exempted from certain third-party testing. Compliance is still always required, but you don't necessarily have to do full third-party testing to confirm compliance. So the Group A tests, you always have to third-party test, even if you're a registered small batch manufacturer. You always have to do lead in paint and small parts and lead in children's metal jewelry. The Group B tests, not mandatory to test, but compliance is still mandatory. So you need to have some way of confirming compliance because you're still certifying your product to compliance of all the applicable regulations. So they're just trying to ease the testing burden for small companies. And that's the U.S. regulations. We're going to talk briefly about the Canada regulations now. And specifically, the Canada Consumer Product Safety Act. Health Canada is essentially the counterpart for CPSC in Canada. Health Canada has been around since the 90s, and we had the Hazardous Products Act for many years. This was revamped under the CCPSA that became effective in June of 2011. And the purpose is to protect the public by addressing and preventing dangers to human health or safety. It's very much a more proactive approach than the Hazardous Product Act had been. They list specific products that are prohibited for sale in Canada, things like lawn darts, products that contain cellulose nitrate, polycarbonate baby bottles, and under the CCPSA, there's over 30 regulations specific to certain types of products. And so before we go any further, just wanted to define some of the terms. So a consumer product really is anything that an individual may use in their home, recreation, sports purposes, and it does include its packaging. So that's an important distinguishing factor. It's not just the product, but it's also the packaging that has to be safe for consumers. And as far as danger to human health or safety, it's really any unreasonable hazard existing or potential that is posed by the consumer product. And that or potential really makes it very much a precautionary type of law. Similar to Europe, they follow that precautionary principle, whereas I believe in the U.S. on the federal regulations, it's more reactionary. If it's found to be a problem, then they regulate against it. Whereas Europe and Canada are looking more, if it could be a problem, let's regulate against it now before it is a problem. And so the CCPSA amended the Hazardous Products Act. And the legislation really was a result of increased consumer concern about consumer products that had been the subject of recalls, so in particular children's products. I think they saw what had happened in the U.S. and realized that they also needed to enhance the consumer product safety regulations. And really, the Hazardous Products Act hadn't been updated in over 40 years, so there was it was time to update. And some of the key changes include new government authority and tools to promote and enforce the compliance and take action where necessary. Health Canada is now able to force recalls, for example, whereas before they didn't have the authority to actually force the recalls. There's some new obligations for industry, and really the end result is that consumers are better informed. So again, the Act gave Health Canada the authority to recall dangerous products, to implement other corrective actions. You see a lot of recalls that are done jointly by Health Canada and the CPSC. The CCPSA requires businesses to report when they know about a serious incident or a death related to their product. So there's now a mandate to report to Health Canada when there's an issue with the product. And that's similar to what happens in the U.S. There's also some documentation requirements that are required for the manufacturers. And, as in the U.S., increased fines and penalties. So the CCPSA doesn't require Health Canada to review or approve consumer products, but it did strengthen the accountability of manufacturers to take measures to ensure the safety. So it's not mandating third-party testing, unlike the CPSIA is for children's products, but it is requiring that you take the necessary measures to ensure the safety of your product. Distributors of consumer products for promotional purposes are considered sellers of consumer products, and so they are subject to these requirements. And while there's not, again, specific certification requirements, like there is in the U.S., there are best practices included in the CCPSA. Number one, testing should be done to the Canadian requirements for consumer products as described in the regulations, and we'll talk about some of the different regulations shortly. Testing needs to be done on representative samples of the products, and we talked about that before. Whatever's being tested by the lab needs to truly be representative of the whole lot and not those special golden samples that, sometimes they make for the lab testing and then they're not really representative of what's going on in the market. And the testing should be carried out at a laboratory that has the appropriate accreditation. The CPSC requires the ISO 17025 accreditation, and Health Canada is recommending the same. The 17025 is a laboratory competency test, and you actually have to get accredited to each individual test. So I want to talk briefly just what is a reportable incident. And then when do you need to report and how do you report? So to determine if you have a reportable incident, there's some factors to consider. The CCPSA defines an incident with respect to a consumer product as an occurrence in Canada or elsewhere that resulted or may reasonably result in an individual's death or a serious adverse effect on health, including a serious injury. So it's not just if it happened, but if it could happen. So near misses are included here as a reportable incident. If there's a defect or characteristic that may reasonably be expected to result in an individual's death, including a serious injury. Also required to report if there's incorrect or insufficient information on the label or instructions. So if you're missing warning statements, for example, you need to report. If you did not include appropriate instructions on how to, for example, assemble a product or how to use a product, and without those instructions, the consumer could do something incorrectly and cause injury, that's a reportable incident. And again, it doesn't have to have happened just in Canada. If you're selling product outside of Canada and you have a report of an incident or you realize there's a potential problem, you still need to report to Canada if the product's also being sold in Canada. And as far as when to report, it's really pretty much immediately. As soon as you become aware of an incident, you're required to report to Health Canada within 2 days. And in addition to reporting to Health Canada, you also have to notify everybody in the supply chain of the incident. So you need to notify your retailers that there's been an incident. You need to notify, so both forward and backwards. And there is an electronic form that you can use to report an incident to Health Canada. And then Health Canada will essentially tell you what needs to be done, whether they're going to require a recall, whether there may be some corrective actions that you may do, whether you may make some changes, ongoing in the future. And there's also a lot of documentation required. The documents are required to be kept for 6 years after the end of the year in which they relate. This is different. In the U.S., documentation is required for 5 years. So in Canada, you need to keep them 6 years. The documents may be kept at your place of business in Canada. The minister may grant an exemption to businesses keeping documents in Canada if it's unnecessary or impractical, but they do expect to immediately be able to get hold of that documentation upon request. And there are some exemptions. If you have a donated product, you wouldn't need to report or include the documentation because there's really little to support product traceability. Health Canada is considering a proposal to exempt, again, the donated product. And they're also looking to exempt product that's being brought in for testing or research or exhibition and not actually going on into the consumer's hands. So the Minister of Health may order manufacturers or importers to conduct testing and compile other information necessary to verify compliance or prevent non-compliance to the CCPSA or its regulations. So it's not automatically mandatory to test, unlike in the U.S., but they certainly may require you to test if they feel there could be an issue. With the enactment of the CCPSA, fines and penalties for noncompliance were increased, particularly if a violation was done knowingly and what they're going to say recklessly. And the amount of the penalty really depends on the risk associated with the product as well as the company's history of violations. This also relates to the import surveillance where the CPSC and Customs and Border Protection are really targeting certain types of products. Infant items are one of those types of products, as well as companies that have been involved in violations in the past. As a result of the differences in how the CCPSA and the Hazardous Products Act were structured, and really to avoid any regulatory gaps, the existing HPA prohibitions and regulations were transferred to the CCPSA. And this was done using the Interpretation Act and a federal regulatory process. And so now we have numerous, over 30 regulations that fall under the CCPSA that may directly affect promotional products. We've talked about the toys regulations briefly, and some of the differences. There's heavy metal requirements in the Canadian toys regulation that's different from the U.S. and European regulations, and so dual testing would be required. Children's jewelry regulations are similar to the U.S., and so you may be able to do just one set of tests. The phthalate regulations are more specific in Canada to just certain types of products. So really, if you meet U.S., you're going to meet the Canadian requirements. But some of these are very different. And as we get into the specific promotional products and what the requirements are, we'll see where there's some differences. There's also, in addition to the CCPSA and all the acts that fall under that, there's the Canadian Acts and Regulations, the Consumer Product and Labeling Act, and this has specific requirements for packaging and labeling, including placement of any statements and font size. And essentially, in Canada, there's a bilingual requirement, as you know. mandatory for warning statements and other certain types of information, strongly recommended throughout Canada for everything. There's also a requirement that there cannot be any false or misleading claims. So any claims that you're making on the product, you need to be able to back up. There is a requirement for marking of imported goods. There's a requirement for product identity, net quantity, and the dealer name and place of business, someone that the consumer can contact should there be any issues. So again, in the U.S., we have the CPSC. Canada has Health Canada. They're comparable agencies, especially with the enhancement on both sides of the border with the CPSIA and the CCPSA. The U.S. and Health Canada are working closely, not just to do joint recalls, but also to better align all of the regulations. I don't know if they'll ever be exactly the same, but they are certainly working towards alignment. But there are differences in requirements, certain requirements for certain types of products. And so that's important for you to know when you're submitting a product for testing. You need to know if it's going to Canada only, or if it's going to both Canada or the U.S., or U.S. only, because it really will affect the testing and the compliance that's required. So the last thing we want to get into are really the requirements by product category. And we've looked at basic promotional products categories. Didn't include children's products here because we've already talked about all those requirements, primarily under CPSIA. But we're going to talk about apparel, houseware, drinkware, writing instruments, electronics, jewelry, and luggage and bags. And if there's anything else you want to touch on, just let me know. Yes, ma'am.
Animals, pets.
Like pet products? That's very interesting. We've recently, like over the last year, I would say, been asked about pet products. And in the U.S., at least, there are not specific regulations for, like, pet toys.
But it doesn't just stop at toys. There's other items that come in contact with pets.
Mm-hmm. And how are you assessing them now?
We send them into UL, to SDR, and identify what they're being used for to the best of our ability.
Mm-hmm.
Whether or not it goes into the hands of a child or an adult, it's all that's asked on the form when we request a quote.
Mm-hmm.
To have it tested. But, we work with a client that has a pet care division. So a lot of the products are directly in contact with
With the pets.
Yeah.
We work with a client that has a pet care division, and all products have to be treated as children's products.
And I think that's probably what we're doing. I don't know if you're working with Haley on that.
No, Lori and Matt.
Oh, okay.
Those are the two contacts.
Yeah, Lori Kivel and Matt. Okay. And so we do have protocol for, pet toys primarily, and we do look at the children's product regulation. So from a chemical standpoint, the lead and the phthalates. And then from a mechanical standpoint, we'll look at the children's product regulations. Sometimes we'll go above and beyond because the biting strength of a greyhound is much stronger than the biting strength of an infant. So you have to take those things into consideration. And it's a challenge because there's not specific regulations. But more and more people are asking for that type of testing. So I think it's smart. You look at the children's products requirements first and then adjust as needed. Good question. We'll have to add that to this then as a big, it's becoming more and more of a major promotional product, would you say?
Oh, has been.
Okay.
I would for the last 5 years, longer.
We will have to add that. For apparel, and this is children's apparel or adult apparel, there are flammability regulations both in the U.S. and in Canada. They're slightly different, so you do have to do 2 different tests to meet both of the regulations. And there's also specific flammability requirements for sleepwear. So from a federal standpoint, you have to test it to the 1610 in the U.S. and issue a certificate, whether it's children's products or adult items. The children's products would require the third-party testing. The adult items don't necessarily require third-party testing. In addition to the flammability regulation, which is enforced by the CPSC, the Federal Trade Commission also requires fiber identification. So that's the actual material that the garment is made of, plus or minus 3%. And then care labeling requirements. You have to include information about how to launder, at what temperature, whether to bleach or not, how to dry, ironing. So those are the basic mandatory requirements for apparel. And then there's other additional considerations, which may be more quality related. So you may want to look at your seam strength or your bursting strength, pilling resistance, color fastness. There's a series of color fastness tests that could be done. Crocking, which is rubbing, color fastness to light, color fastness to water. And it's more quality related, but if you have an issue, you could get customer complaints. You know, you don't want this black dye rubbing off on my neck, for example. Drawstrings in both countries have been identified as a substantial product hazard. Drawstrings in children's upper outerwear are banned. And yet, I continue to see recalls for drawstrings in children's products at major retailers like Bon-Ton. They've had to pay a significant civil penalty recently because of the drawstrings. There's other attachment methods. With regards to the houseware and drinkware, there are specific requirements in the U.S. that are enforced by the FDA, part of 21 CFR. And there's also guidelines for ceramic ware. And Canada has the glazed ceramics and glassware regulations. We're essentially looking at lead and cadmium with the ceramic ware. There's also a ban on the use of polycarbonate, which contains BPA, in infant bottles and sippy cups. And Canada has the consumer products containing lead regulations, which essentially limit the total lead in those items to the 90 parts per million or milligrams per kilogram that we talked about earlier. So those are the federal requirements, but there's also additional considerations. When there's decoration around the lip and rim area within the top 20 millimeters of a drinking vessel, there is a technically voluntary ASTM standard that's widely used to ensure, just again, that the lead and cadmium extraction that comes from that area. The state of Massachusetts has a total immersion test. California, of course, has their Prop 65, as we've talked about. And then from a quality standpoint, you want to look at things like dishwasher safety, microwave compatibility, heat retention if it's a thermal and insulated type of product, lid fit and leakage, stain resistance, breakage. These pop-top type of water bottles, there's been a lot of recalls because those tops can detach and they present a choking hazard. Not allowed for children under 3 due to the small parts regulation, but really for any water bottle, you don't want consumers putting these in their mouths and having the small part detach. The sippy cup that's pictured here was actually recalled because the liquid in the middle where the dolphins are swimming was a petroleum distillate, and it could leak and poison children. I mean, not the smartest thing to put inside a drinking vessel, even though, of course, the intent was that it be permanently enclosed. With regards to writing instruments, there's not a lot of federal regulation aside from art materials. Art materials have to be, evaluated by a board-certified toxicologist and need to be labeled with conforms to ASTM D4236. This doesn't apply to standard wooden pencils. It doesn't apply to single-color pens. Most writing instruments are not considered children's products, even if they're distributed as like a back-to-school item. The CPSC has ruled that most writing instruments would be considered general use items. And of course, there's some exceptions. If you have a goofy character, if it has like a little maze on top or something like that, that could be a children's product. But for the most part, writing instruments are general use. There are some voluntary industry standards and certification programs. For crayons, there's an ANSI standard that really just looks to ensure consistency of the crayons. They look at like wax content and color and things like that. As far as potential concerns, if it is a children's product, you need to meet all the children's product requirements. You also may want to look at the lead content of surface coatings. This pen, which truly is a general use pen, was recalled because there was high lead content in the paint on the logo there. Didn't fall under mandatory regulation, but it was recalled because high lead was identified and the manufacturer decided to do a recall on it. So with anything, I would recommend look at the lead content in the surface coatings, even if it's doesn't strictly fall under a mandatory regulation. With electronics, there are various standards such as UL, CSA, ETL, and the standards are specific to the types of electronic products. With electronics, typically they have a higher perceived value, and so you'll want to make sure that they function properly and don't cause a hazard. I just saw a recall yesterday I wouldn't say it's an electronic product, but I was just surprised. It was a jacket that included heating, right?
Yeah.
That included some heating components to help keep you warm. What a great idea. But it burned. It overheated at the wrists and caused burns on the wearer's skin. And that is a potential concern, really, with any electronic product, is the overheating. As far as batteries go, there's a regulation that they can't be accessible without the use of a tool if it's in a children's product. But really, it's a recommendation for any product. Just make them not accessible without the use of a tool. You need to use a coin or screwdriver. Battery leakage can be an issue, along with the overheating in any number of products. And Prop 65, probably some of the first settlements were due to the PVC cords and lead content. So you do want to look at that if you have a corded product. There is a restriction for mercury in batteries. And performance is an issue with the electronics products because, again, of their higher perceived value. With jewelry, there are children's jewelry regulations that limit lead content, both in the U.S. and in Canada. For adult jewelry, really, in the U.S., there's something that looks at the precious metals, but for standard adult jewelry, there's not a regulation. But there is an ASTM regulation that is currently in committee that would apply to adult jewelry, primarily looking at lead and cadmium in jewelry and nickel. There is an ASTM standard for children's jewelry that was passed last year in the U.S., and the state of Rhode Island made it mandatory to comply as of December of 2012. So essentially, if you're distributing children's jewelry in the United States and you don't have control over which states it goes to, that ASTM standard became mandatory to comply with. It goes above and beyond the lead content. It looks at all heavy metals in the surface coatings. It includes requirements for breakaway strength, looks at liquids that can be used in children's jewelry, has nickel content requirements. And jewelry doesn't necessarily mean what we would typically consider jewelry, but there's also been zipper pulls recalled because of violations of the jewelry requirement, keychains. So the scope of what may be considered jewelry is fairly broad. Luggage and bags, there's really not any federal regulations for adult items. If it's intended to hold food, you're going to have your food contact requirements. And for children's bags, like those Mulan bags, there are all the basic children's product requirements. Prop 65 has been pretty active lately with bags, looking at phthalate content in particular, as well as lead and cadmium. There are some state restrictions in the U.S. For example, the state of Connecticut, where I'm from, considers lunch bags as packaging material. And so, I know, I don't get it, but requires that the lunch bags meets the toxins in packaging requirement. Plastic bags do need to include a suffocation warning if they're of a certain size, and this is mandatory both in the U.S. and in Canada. And of course, in Canada, it needs to be in French as well as English. Take a look at cords on bags. Some of these bag sacks with the cords really, while they're not regulated against children, you really wouldn't want to distribute them to very young children just because of the potential for strangulation with those cords. We talked about test reports a little bit earlier. We do recommend that you get a copy of the actual test report that's specific to your product. You can just request the certificate, but the certificate needs to be based on something. How is the manufacturer certifying compliance? How do they know it complies? So we do recommend getting a copy of the actual test report. The test report should specifically identify your product. You don't want a generic, all of our inks meet CPSIA lead requirements. You want to know which specific inks because you want to match that ink to your product. We do recommend that they be fairly recent within the past 12 months, which is going to be mandatory next week for children's products in the U.S. The testing should have been done by an independent third-party laboratory, ideally one that has the ISO 17025 accreditation. And the report should list all the applicable tests rather than a generic, my product meets all safety requirements in the U.S. I mean, what does that mean? Was it tested for lead content? Was it tested for phthalates? And recommend that the report include the actual result. We had mentioned earlier, not just lead content pass, but what was the limit? I mean, how much lead was found? Is it close to the regulatory limit? And that's really the end of the presentation. I really appreciate all your input, too, and the interaction. The pet toys or pet products is something we're going to have to add. The Prop 65 discussion was good. That's a challenge for everybody. But are there any other questions?
I know I came in late, I apologize. Are there any items, and you mentioned paper products, that have a clear exemption?
Yeah, paper products would be a very good example because they're exempt from lead content. If they're using the CMYK inks for printing, they're also exempt from testing. They don't require mechanical tests or flammability.
How do we convey that to the client when they're asking for
A certificate. Okay.
a gift bag,
Mhm.
paper bag, and clearly say to them, it's exempt, it doesn't need to be tested? Do you have a list of anything that has clear exemptions?
Yeah, that's what I was gonna next ask. So if I come across something that I feel it could be an exemption, I could go to them.
Mhm.
And they could give me something in writing saying,
Yeah.
testing not required.
Yeah. And we've come across that where, some distributors are just like requiring that certificate. But there isn't a certificate because there's nothing that's required. So it can be a challenge, The distributors know they should be asking for a certificate, but sometimes it's not needed. And that is a challenge. But yeah, ask Lori or Matt and they'd be able to send that to you in writing.
I saw that. Adult watches don't need to be tested. Really?
From a U.S. federal standpoint, true. Right.
Where to review our email, would you mind sending the slides out? Is that a possibility?
Yeah, absolutely. And I believe it's going to be.
Yeah, the presentation would be great because there's so much.
There is, I know. And I believe, Chantel, it's going to be posted, correct?
It will be available on our live learning center, free of charge, so you can access it at any time.
But we'd be glad if you want to give us a list of the attendees, or just if everyone wants to give us their business card, we'd be glad to send out the presentation to you as well. And then you'll have our full contact information, and if you have any other questions, you can reach out to us. Any other questions? All right. Well, thank you very much. I appreciate it.